A few weeks ago, we shared that House Bill 687, also known as the Hidden Predator Act of 2019, was being sponsored by CT Wilson. House Delegate Wilson's bill would end Maryland's statute of limitations for civil claims against perpetrators of child sexual abuse and would also include a 2-year look-back window, a time which victims could bring claims in cases where the previous statute of limitations has expired. If you've seen The Keepers, you will remember Delegate Wilson speaking on his experience as a survivor and how hard it is to pass laws that the Archdiocese fights against. This week we want you to hear Delegate Wilson's speech, as well as the back and forth in Annapolis, Maryland in March at the Judicial Proceedings Committee. 1 in 4 girls and 1 in 6 boys are sexually abused in the United States, and to this day, most still have not disclosed their abuse publicly.
Thank you, Mr. Chair. Note that the panel is not here to talk, they're here for questions. As we discussed earlier, I understand that this is the Senate, and you guys want basically sponsor only, so they're here for questions because, as you well know, there are some legal issues that have arisen, so these are all people that are just here to any questions we might have after the presentation, if that's okay. So I have with me Claudia Remington, Catherine Robb, and Wendy Lane. And I just want to acknowledge, thank you, Dave Lorenz, and for the survivors that have come to hear this hearing. Again, excuse me if I'm a little disheveled. This has morphed into something a lot bigger than I thought it was going to be when we first presented. But I know when I first spoke with the House a few weeks ago, I said I was presenting this House Bill 687 to right a past wrong. And I said that because at the time I had worked very hard on a bill for years, and many of you were either in the House, some of you were in the Senate, and you'd heard my presentation year after year, given my personal story, not even getting a vote in either House or the Senate. And so by the third year, I was exhausted. I'd had a lot of individuals come and testify, and I was tired of seeing people go through that. So I did what I thought was the right thing to do, and I worked with individuals, including the Catholic Church, to try and craft a bill that everybody could be happy with and we could get through. And at the time, I didn't realize that gross negligence burden that was placed on individuals between 25 and 38 was a very high burden civilly, and it was hard for them to go forward. Now, that alone, but what really got my attention was, and I just want to give me a minute to talk about some of the other things that passed through my mind, including the key schools, 20 years of sexual abuse and misconduct from the 70s through the 90s. 18 former students were victims. One 14-year-old girl, became pregnant and had to have an abortion because of a child sex abuse. The Landon School was reported in Washington Post. Archdiocese of Washington, 31 clergy members, credibly accused of sex abuse with minors from 1948 onwards, including Cardinal McCarrick, who had to step down. Larry Nassar, we've all heard, that was the gentleman from State University. R. Kelly, we've heard that one. What really caught my eye was the Pennsylvania grand jury report. 300 priests in 6 dioceses that they investigated and implicated, but others they couldn't find. And I read through that report, and it was roughly 900 pages. Thank you, Claudia. The way that even the FBI was surprised at how well this was hidden. Poorly it was documented. Priests were raping children and then moving the priest around so they could have a new playground. Never told the police. The FBI said they knew they were doing it, knew how they were doing it. They just don't know how much they were doing it. And it was being done on their own property. And to the end, over 500,000 pages of discovery was finally turned over, having to do with child sex abuse from the Catholic Church. People raped in places of worship and schools. People that weren't doing it but were aware. But it was the odious stories of predator priests taking photographs of little boys while they stand in the crucifix position, telling that they're posing to be for statues, having them take off their underwear, taking Polaroids. Or when they provided golden crosses to certain little boys that were victimized. Because you know what? It wasn't just a gift to keep them quiet. It was to let other priests know that this was a soft subject. This was a victim. He'd already been groomed. That's when I realized that it wasn't enough. Raping a 7-year-old little girl while she was supposed to be getting her tonsils taken out the hospital. Forcing a little boy to provide oral sex and then washing his mouth out with holy water. And that's Pennsylvania. That's right up the road. Little boy drank some juice or wine at a priest's house and woke up with a bleeding rectum. See, this is the FBI report. This isn't something I'm making up. So whoever comes up after me and says, yeah, but not Maryland, we touch. People have called me from California saying, yeah, you've been a dumping ground for generations because they know they can get away with stuff in Maryland. This is not an attack on the Catholic Church because believe me, I'm not Catholic and you've heard my personal story. But if they want to fight, I'll be damned if I don't fight back. See, it was brought to my attention that I'd made a deal with the devil and I did not know how much I did because while I'm sitting there negotiating with the church, trying to get something we could both realize. And I realized, unfortunately, that burden that I set was a little high. What I didn't realize is something many of you here didn't realize either. It's called the statute of repose. Many of you are here. I'm sure no one knows what that means. However, in our 2017 bill, and you might hear some testimony, because I was shocked to hear it on the second reader in the House. The Honorable wrote a memorandum of law about some language that was snuck into our 2017 bill that pretty much would exonerate the Catholic Church in perpetuity from any retroactive activity. That's how deceitful this is. This isn't our bill, our language. Somehow amended in and then used in defense, knowing that was never the intent of anybody in this legislature. I'm glad that people are here today and you don't have them testify because I'm really tired of seeing people put themselves through that. I know how emotionally painful it is, how destructive it is to myself, my family, and my mental and physical health. So I'm very grateful that they can sit back there and they don't have to talk again. Thank you. But it's time we stop looking and say, you know what? If we do this for these guys, then, well, what about the builders? Do you understand that this is child sex abuse? The average age for even reporting is 52. I didn't even start dealing with mine. I was a combat soldier. I had killed people and I couldn't deal with my childhood. I got through law school before I finally woke up because you know what? I had a child. And that's when it dawns on most of us. When we see a child 7 years old and we see the mannerisms and we see ourselves and what was taken. This is definitely not a pity me story because I don't care. Because right now the Senate, interestingly enough, is on a neat little precipice of historic proportions. Because you know why? Clearly, the statute of repose, which you may hear argue is the whole only constitutionalist you could possibly have. Clearly, that was not the intent of the House, and I don't believe it was the intent of the Senate. But that language inserted creates a constitutionally protected and vested right for child predators and the institutions that harbor them. Currently, that's the way they argue the bill. But see, it's been brought to light now. And the House did act because it was defended. They were argued on the floor and it was slapped down 135-3 because that was never our intent. Ever. Look at the language in 2017. Many of you were here. Ask yourself, was the statute of repose ever discussed? I'll tell you what it is because I didn't know and I still really don't get it. But it's a construction law. And I mean that for people who are in the art of constructing buildings. It protects them from claims in perpetuity because and there's experts smarter than me here, but the reason we know that it doesn't fit, not only is because it's construction, is because the way that law, the statute works is from the moment you turn the building over, from the moment you complete the restoration, from the moment you've developed the product and you turn it over, that's when it starts running. Because our legislator said, we don't want people to be held 30 and 40 years down the road for faulty building, for mistakes in development. We give them a little time, but it doesn't start on the injury. The time does not start tolling on the injury. It's on an act of the defendant. There's case law. We have a memorandum of law. If you please read it, it makes it very clear how this could never be a statute of repose, even if that's what the word said, because the intent of the legislator was not a statute of repose, because it acts on the injury. That's what a statute of limitations does. Please read the law. It's very clear. It's very duplicitous that they was snuck into a bill that this body put out in 2017. and then used in our face, like from this point on, you have to exonerate us from any past wrongdoings. Retroactively, you can't come after us. But even more, you should be somewhat patently offended that they're telling you that you've tied the hands of that in 2017, we've tied your hands. Because there's no law that we should be writing here to prevent future legislatures from doing their job. But that's what's being told today. I'm not here on a witch hunt. I've done my research. You're going to continue to hear it. I don't matter what happens today. You're going to hear tomorrow, a month from now, other states that are discovering horrible acts of perdition. We always talk about being one Maryland and how we're going to be the forefront. How can we not protect our children? And I'll say lastly, it's not about revenge. The reason the statute, the 2-year look back window is so important. For example, in California, because of that 2-year look back window, 300 additional predators were found. And know this, they don't stop at 30 and 40. They go all the way up until their 80s. We have a compelling state interest. This is a compelling state interest to protect our children from predators that are still out there, that will only be discovered, unfortunately, by lawsuit. I know I do a lot here in the state house. It's inappropriate. I have a short temper, and I don't have a lot of friends. I had a tough childhood. But I don't want my legacy on that 2017 bill to be that we protected this church and we protected the wrongdoers and the predators infinitum, that they'd never have to pay for anything they did in the past. That is not just. That is not right. It's not why I ran for office, and I never want that to be my legacy. I know it's tough because I'm sure that we always worry about the nose under the tent of the camel, or the nose under the camel and his nose under the tent, all that nonsense. But that's why we're here. We create laws as we go. I asked for your support in House Bill 687. I would love to have any questions, because what I would love more than ever, win or lose, is for the bill to get a vote. For the people to stand behind me that feel that their voice is heard, even if you disagree. Because we all deserve that. Questions?
When was the last time that you guys can all take a seat? When was the last time that we did, if any of the three, because I remember when I was in the House, this bill first came up, that's a while ago. We did a 2-year look back then. Does anybody remember the date?
That was the Dovey Road case was where it was tested. I think it was 2003, 2007.
So we had passed, remind me, we passed a law back then was that the year that we did the 7-year statute of limitations? I just don't remember.
It was either 5 or 7. I know it was an increase, 2003. And it was but I know that the statute of limitations was increased, and the courts found that our intent was a look back window, even if it wasn't specified in the.
That was going to be my second question. I was a freshman legislator, so in the House, what was it specified in the law, a 2-year look back in the?
I don't remember being specified in the law, but courts. But the way it was, because the young lady in the Roe v. Doe case, the courts found that that our intent was to have applied.
Okay. Anyway, so there was in 2003 a 2-year window.
It was put in the bill. It was taken out in writing. However, the courts found that even though Ms. Roe had filed, there was a delay in her filing, I believe that they allowed her to do it. What?
So I believe it was in the bill. It was taken out, and there was an attorney general opinion or letter back then to Chairman Frosch saying that this was unclear, that the constitutionality was unclear. It could go either way. And that there's notation in the AG letter of this year to Delegate Dumais in the footnote that says that the Assistant AG, Catherine Rowe, gave the same advice to Chairman Frosch that it was unclear the constitutionality could be upheld. So the courts had not decided on it at that point. But at that point, it was amended out of the bill. So we have, as far as I know, after that, I don't believe there was a look back window. They've tried to put a look back.
The reason that at first when I filed the bill, that wasn't as important to me until I realized it would happen in California. And again, the overarching goal really is not about vengeance or even a voice at this point. It's making sure that there are others out there, we can get them. Not being by others predators.
There's uncodified language And Chairman Frosh, is it Frosh's bill? Hold on, sorry.
Right, that's the old bill. The bill that
Senator Kelly's bill, 2000. It was Dolores Kelly's bill, 2003.
But the uncodified language I was discussing was a 2017 language.
How does that read?
It's very convoluted. So I believe we provided some documentation, but I know it was fairly convoluted.
The question is 2017. Is that
Yeah.
Mary has.
What is the? Yeah, I'm looking.
And I know the intent
Senate
of that,
chapter was 656.
and the intent at that point was not to be retroactive. We had agreed that and we agreed, and there was no discussion. We agreed at that time that we were trying to make it retroactive. We weren't opening up a look-back window. I wouldn't know where I'm not in judiciary, so if you briefed judiciary, but everybody I talked to in judiciary said they had no idea, especially again with regards to the statute of repose, how it got there. Yeah. And I'd never, we talked about, I'd never heard about the statute of repose until the day before we were going to argue this bill, including any briefing. I'll say this, I was never briefed by the chairman. I'm not on that committee, so I'm not sure, but I know that we debated the bill on the House floor. Nobody mentioned the statute of repose. When we discussed the bill, when they discussed in the committee, from every committee member I spoke with, including Delegate Ep31, who's now the vice chair, there was never any recollection explaining what a statute of repose was, or how would in fact create what I guess they argue is a vested right. And so that was very unintentional by anybody I've spoken with, and yourself included, Mr. Chair. I know we've discussed this. We were learning about the statute of repose together a few days ago.
Thank you, Mr. Chair. I was just going to say that somebody intended that the word statute of repose be in this amendment. As I'm looking at the original amendment dating from a couple of years ago, amendment number 1 says insert, quote, establishing a statute of repose, and continues. And then further down, it specifically says, it talks about statute of repose.
I don't disagree that somebody did. Clearly, because it wasn't, those letters didn't fall together on accident.
Yeah.
The point is, no legislator that I have spoken with has, and that's again where my frustration comes in, because we're always told about what trust committee process.
Yeah.
And also we look at the codified language usually, quickly before we vote on a bill. So I hope it's not going to be our worry now that we have to read every single point of every bill as it goes through the House and Senate to make sure nothing's being snuck in, especially the antithesis of what I was trying to do. Because the statute of repose, which again isn't properly placed, it's legal fiction in this setting, is an opposite of what I was trying to do. I'm trying to provide voice for the victims, not shut them down. So knowing that's snuck in, and I will say surreptitiously, because that's my bill, I can say that.
Yeah, clearly it's your bill.
Right. So I did not, again.
But you weren't a member of the Judiciary Committee.
I was not.
In between the time that you finished testifying and the time it arrived on the floor, that amendment had been added by the Judiciary Committee. Somebody wrote it, and then the committee obviously voted in favor of it.
I didn't see it on the House side.
Yeah.
I'll be honest with you. And we have poured through every little bit of paperwork that we had, any amendments, anything going through. And again, I know, because I know the players that I'm dealing with, that I don't know who put it in it. Because unfortunately, when they put amendments in, I could say I wanted in Senator West's name, drop me this amendment. Yeah. So again, the point being, if nobody intended to do it, I'm not an investigator. I don't really care how it was done.
Right.
Or at this point, I can tell you why it was done, clearly. But it wasn't the intent of the people, and therefore they had defrauded the body and the citizens of this state.
Got you. Thank you.
Yes.
Briefly.
Yes. Yep. Very briefly. First of all, thank you, Chairman and committee members. Just a couple of things about the language within that uncodified. If you look to even Black's dictionary, a statute of repose is triggered by an event or an action of the defendant. For example, you can look to your own statute here in the state of Maryland. It is something like the completion of a construction project or putting a product into the stream of commerce. It's triggered by an action of the defendant or alleged defendant. And I might add that even in the letter, in the venerable brief on page 2, they say the same thing, that it is the event or action by the defendant. But if you look to the language in the uncodified language piece, it is an act essentially by the plaintiff. That act would be simply reaching the age of majority. Now, I know that Delegate Wilson also touched on the fact that historically across the country and as well as here in the state of Maryland, that statute of repose have been used for two types of cases: construction cases and products liability cases. Occasionally you'll find in a state a medical malpractice, and they have exceptions there. So not only is it not the typical language and contrary to something as simple as Black's dictionary, but it is also historically not used in these types of cases, which I think speaks to the ambiguous nature and the clandestine appearance of that, which made it hard for Delegate Wilson and many others to fully appreciate that language. Thank you.
Thank you. It's my first time hearing the bill. And there's a lot of letters of support here. I was just curious on the green letter from the Office of the Public Defender, and they don't take a stance, but they just point out that there's two possible changes that would have to do with like teenagers sexting each other. Have you seen
I've had to curse them out already because, yes, they're not wrong. I just wish they'd have caught it before it left the house because our goal is not to entrap people.
Yeah, I know that.
So and unfortunately, yes, this is to pass the Senate and it would have to come back to the House because those are changes that we don't disagree with. I understood we don't want it, and I think we've discussed.
Actually, not the exact changes that they had, but really if you had look at the current bill in the House form, if we just put in on page 2, line 6, an adult allowing or encouraging a child, that would take care of the issues that we had a discussion with the public defender. I think he's still here. And he said,
or person of majority. We spoke with the guy from the PD's office. Unfortunately, they didn't bring it to us because it's fairly nuanced and small.
Yeah.
It really is chances of you suing somebody for what a kid. But again, we're trying to craft good legislation. So I understand that.
So will you be submitting an amendment or?
Can.
Okay.
Well, it's basically if you look at 2, line 6, because it doesn't specify adult or person of majority allowing or encouraging. They're worried that it could be used against children. And that's never the goal. They have a child induced another child to sext and
I don't want to clarify. I'm in full support of the bill.
So,
I just was curious about that one.
No, that's the goal. That's not the goal.
I know.
So if you'd like an amendment, Mr. Chair, I'd be more than happy to.
We just had an entire bill hearing on this issue because there is a Court Special Appeals case related to this. Not quite.
You guys, was it a Senate bill or a House bill? Because I put in a House bill. I don't think it made it out. I put in a House bill because I thought the law was ambiguous in it. I didn't want to entrap children in sexting either.
Yeah, it was specifically on that issue.
Yeah, I had a bill in the House too. Maybe those will get out.
All right. Any other questions? We are going to hear from the opposition now. Mr. Carrie Silverman.
Thank you, Mr. Chairman, members of the committee. My name is Carrie Silverman. I'm here today on behalf of the American Tort Reform Association, which is a group of associations, businesses, nonprofit organizations, and municipalities in Washington, D.C. here, a national group. I commend the committee for considering this legislation and doing what it can to protect children, and the sponsor for his advocacy today, and the many victims that are here in support of this bill. I do want to express our concerns with this bill, as we would with any type of legislation that would completely eliminate a statute of limitations and revive time-barred claims. It's unprecedented in Maryland law to completely get rid of a statute of limitations. For any type of claim, we have statutes of limitations. They're not based. They may be viewed as arbitrary. They may be viewed as unfair. They often are in individual cases. After all, you are taking away the ability of a person who may have a viable claim of the ability to bring that claim. And we all want to have everyone have their day in court, but we still have these statutes of limitations in place for any kind of action. And we have a statute of limitations that's finite, whether it's a wrongful death case involving a child who was killed, whether it's a toxic tort case where someone developed cancer and died because of someone else's misconduct, drunk driving cases. every kind of case, usually it's 3 years from adulthood. In some other cases, we've made it 5 or even 10 years. And it's based on the kind of evidence involved. It's not based on the type of injury involved, how tragic it is. It's usually not based on the kind of conduct that's involved, no matter how horrible it is. It's based on the kind of evidence involved. It's there so that to protect not just defendants, but it's there to protect the courts and to make sure that judges and juries, when they're deciding principles of liability, whether someone or an organization did something right or did something wrong or didn't do enough, that they do it with the best evidence available, that they do it when the witnesses are there to testify, that they do it before the documents are thrown out and the records are thrown out, and they do it in the time where people understand what was known and how people should have acted. And that's why we have statutes of limitations. Now, most states, as Maryland has said in childhood sexual abuse cases, victims need more time. And at least 40 states have enacted specific statutes of limitations for childhood sexual abuse that are significantly longer than the 3 years you'd have ordinarily from adulthood. You increased it here to 7 years and then to 20 years. So that's where we are today. And legislatures have taken that approach, and they've done it prospectively for the most part, and they've done it with a finite period of time. There are exceptions. Now, there are some states that have taken an approach similar to this bill, and you might feel like that is the way that states are going today. But there are only, and most of those states have significant limitations on what types of claims are revived. But putting that aside, the reason most states have not taken that approach, well, it's twofold. The first are the public policy reasons that I've already discussed with you today. The other, constitutional concerns. In many of states that have considered the issue, the courts have indicated that reviving a time-barred claim is considered unconstitutional because it impairs a vested right. That's regardless. I know there's been a lot of talk today about the impact of this statute of repose language that is in there. Now, most states don't have that issue, and I haven't seen that come up before. But just purely based on the statute as it was enacted before and the statute without that language, just on the basis of a statute of limitations, not repose, most courts have said that interferes with a vested right. And that is a principle that is important to both plaintiffs and to defendants. And I'll just read to you very quickly what the Maryland Court of Appeals itself said in a 2002 opinion. It said, "We have consistently held," this is a quote, "that the Maryland Constitution ordinarily precludes the legislature from retroactively abolishing an accrued cause of action, thereby depriving the plaintiff of vested right, and from retroactively creating a cause of action or reviving a barred cause of action, thereby violating the vested right of a defendant." So it goes both ways. Just like the legislature would not say in a personal injury action, change the statute of limitations retroactively from 3 years to 1 year and take away someone's right to sue who is in that 2-year area, the same principle applies when applied to defendants. And that's based on the statute of limitations. And in 2011, the Court of Appeals again looked at this issue, again without the statute of repose issue being there. And it said that extending the statute of limitations from 3 to 7 years could apply retroactively, but only to those claims where the statute of limitations had not yet run. And it said that, and this is another quote, "We would be faced with a different situation entirely had the plaintiff's claim been barred under the 3-year limitations period." So that's the law as it stands in Maryland today. Now, the statute of repose suggests that language that's in there, that there is even a greater chance that the court would view this as unconstitutional, purely for the reason that a statute of repose is typically considered a substantive part of the law, whereas a statute of limitations is more procedural, and changing retroactively a substantive law is typically also viewed as unconstitutional as well. So in conclusion, I would ask you to continue the longstanding tradition of always having a statute of limitations, a finite one for civil claims, and making changes to the law prospectively. We're very concerned as to how the changes made today will impact toxic tort cases, product liability cases, all kinds of medical malpractice where things may be discovered in the future and may be viewed differently 30 years from now than where they are today. It's a precedent that's being set today that will impact other kinds of claims.
As to the statute of limitations constitutional claims that you're talking about, So I'm trying to look up states that have no statute of limitations, and there's some.
Yeah.
So, for instance, Delaware. Delaware has no. Are you familiar with that?
Yes.
I would assume at some point in time that was not always the case. So at some point in time, the legislature in Delaware moved from some finite statute of limitations to an infinite statute of limitations.
That's correct.
That's
it
accurate.
was roughly 10 or 12 years ago. Yeah.
Okay. So in the state of Delaware, not that's our court system, but in the state of Delaware, have their courts ruled the way that you are inferring our courts would rule?
There's a split in the courts. A majority of the courts have considered the issue have gone the way that I discussed. Delaware goes a different way. They follow what I would consider is the federal approach under the U.S. Constitution. The U.S. Supreme Court has said that retroactive they can't do it for criminal laws, but they can do it for civil laws. Delaware is one of the states that follows that approach, and about a third of states do.
And then that Maryland's court, what's the court? What are you referenced 2 Court of Appeals cases. What are the 2 references for that?
The 2 references are the Dua versus Comcast decision in 2002, 805 A2D 1061, and then the Doe versus Roe case that was mentioned earlier today from 2011. There are others, but those decisions indicate that Maryland sides on the greater level of due process protection that the majority of other states do.
There's no case on point in terms of this specific issue in Maryland, though, right? Because when we raised it a couple of years ago, I would assume that there were some number of cases that were brought because we went from a 7-year statute of limitations to a 20-year statute of limitations.
To my knowledge, there is no recent, no modern case that is, when you say on point, I think the quotes in the decisions are on point, but there is no, and I think this is why there's some in the Attorney General's prior opinions, while we don't know for sure, is that the 2 decisions that I read weren't dealing with specifically a revived cause of action. They made statements in those decisions, which you might say that's dicta, but they made very clear statements in both of those decisions indicating what approach Maryland follows, but they were not specifically dealing with a revived cause.
Notwithstanding, I'm not sure that the constitutional potential issue is a rationale for not moving forward with a bill like this, right? That's a erudite conversation for the Court of Appeals to have. I'm not sure that's the reason we should or should not move forward. We certainly aren't going to take the Attorney General's opinion for anything other than just one person's opinion on a given day. So I guess I don't know, I'm not sure how to ask this question. What has been the effect of moving? There are 11 states, you said, now have an infinite statute of limitations on these?
No, there are 11 states that have retroactively revived time-barred claims. There are, I don't know the exact number that have eliminated a statute of limitation, but it's lower than that. I know you mentioned Delaware. I believe Florida and at least one other state have done so prospectively, and there may be another 1 or 2 that I think,
When you say prospectively, you're saying for actions that occur now or for individuals who weren't time-barred. So would that, when you say for actions that have, are you talking about somebody who maybe 15 years ago now is years old and their statute's about to start rolling?
When I talk about reviving a time-barred claim only for cases where the statute has already run, in terms of what's constitutional, if a case is already or a claim is in the middle of a statute of limitations period and the time hasn't run out, there's no case law that I'm aware of that says you can't extend it for those claims, just like the Maryland Court of Appeals said in the Doe versus Roe case. If you're, say, 4 years into the 7-year statute of limitations and you were to change it to 20, that's okay. That's not a constitutional issue.
You're saying the concern would be if you were 8 years past the 7-year statute and then we come and make it 20, you're saying the person who you believe that our Court of Appeals, at least language, would say that is a time-barred statute. That's a time-barred claim that can't be revived by legislative action.
That's my reading of the cases. Yeah.
I would assume that those are making their way up, though, right?
What
I
court
would
decision?
assume that case is making its way up. If our 2017 law has any effect at all in assisting individuals, the a window of individuals who could be filing a lawsuit, you believe, without constitutional merit. But I would assume that they're filing those suits right now.
Well, the 2017 legislation, as did the 7-year increase, both said very specifically in it that they didn't revive time-barred claims. So it's someone might still make that, but I don't think that they're going to have much of a basis in the law for pushing that.
All right. My last question is, as to this issue that Delegate Wilson was talking about, which is the statute of repose, that's a construction. I vaguely remember it, something from years ago when there was a bill about statute of repose for construction cases. I've never heard, and I'm a plaintiff's lawyer, I've never heard that terminology used in personal injury cases. Are you aware of any where the statute of repose is used in
just
personal
in
injury?
one area? And the witness who was up here and on the prior panel had it exactly right in my experience, which is you see statutes of repose most often in the construction defect claims. You see them very often in product liability claims, which are personal injury cases, but you see them very often in where the time period for bringing a claim will run from the sale of a product for 10 years. 10 years is 10 or 12 years. Probably about, I want to say, a third of states have a statute of repose for product liability actions. And then you see them very occasionally in medical malpractice, where it will run X amount of years from the treatment rather than from the injury if it's discovered. But those are relatively small number of states that I'm aware of.
Strange law. I don't remember it at all from law school, quite frankly, but like it's a strange law to say that even in construction, if you think about it, right, you're going to disagree with what I'm about to say, but from the Tort Reform Coalition, but just hear it anyway. Like it's some guy gets a house falls on him because of some defect that somebody did something wrong. I don't know. It's 30 years ago. The guy did something wrong, but what does that matter really to the guy who had the house fall on him? And somehow the statute of repose protects that individual.
I personally have not dealt with the statute of repose in the construction field. I have dealt with it in product liability actions. And the policy underlying it there is that after a product may be sold and it's out there for an infinite potential amount of time, whether it's a refrigerator or whatever it might be, a car, but after some number of years has passed, 12, 15, 10 years, there's just a understanding that at that point in time, if something goes wrong with it, rather than it being some kind of defect that happened at the time of the sale, it is understood that is most likely because of the wear and tear and some other problem or misuse or something else. And so we don't want to have that litigation in the courts.
So that, I'm glad you put it that way. And I'm not sure I necessarily think that's rabidly fair either, but putting that aside, that seems wholly inapplicable to what we're talking about here. I'm just suggesting, just in terms of, I don't know how these things get constructed or all the rest, but that does seem that I'm not sure that there would be a parallel kind of way to think about that in this. I get your conversation about statute of limitations.
And that's why I focused on the statute of limitations.
And I think that's a fair, although I'm not sure I necessarily agree or think that our Court of Appeals would agree, but that's not for us to say. That's just two litigants going at it in front of the court, and that's fine. But as far as the statute of repose, I can't for the life of me think that there's an applicability in this realm that makes any sense.
Yeah,
would you agree with that?
I can't speak to that issue. I don't know as apparently the sponsor didn't know how that ended up in the bill or where it came from or what it looks like. I could understand what the intent of it was, but I was not part of that. And
regardless of intent, I'm just not sure that it has any applicability. I can't. I'm not sure you can just stick those words into any particular bill and say you have a vested. I've never seen that before, and I'm just you represent the Nationals, so I'm just wondering.
I'll tell you, I haven't seen it. I haven't seen it either.
Okay,
yeah, but that's why I focused on the statute of limitations.
Okay,
yeah.
Fair enough. Anyone else? No. Let's go one man.
Okay. Thank you.
Thank you very much. Thank you very much for your testimony. That does a testimony on House Bill 687.
House Bill 687, the Hidden Predator Act of 2019, was voted out of the House of Delegates 135-3, which allowed it to proceed to the Senate Judicial Proceedings Committee. The bill failed to move forward when the committee deadlocked at 5-5. In a recent interview with bill sponsor CT Wilson, he was asked if he would introduce the bill again next year. He said, "Of course, I'll probably try again, because they deserve it. These folks deserve to know that somebody's trying to fight for them. I want these predators to be terrified, looking over their shoulder for the rest of their lives. For the destruction they caused, I want them to be nervous as hell that this bill might pass one day.